In another context, we've seen it arise in some political realms where there's a case out of the Eastern District of Virginia where a sheriff was elected or re-elected, and then after his re-election he fired 6 employees because they had friended on Facebook his competitor in that election. My name is Wade Harrison. I work with the law firm of Godfrey & Kahn. It's a full-service business firm, but my specific practice area is labor and employment in addition to healthcare. And in the labor and employment realm, we represent employers, so we're a management side firm. Today we were talking about managing employee conduct that occurs outside of work, so off-duty employee conduct. And one of the reasons that that's become a more prevalent issue is because of the changes in technology, the expansion of social media, so issues that employers may not have been aware of in years when the technology did not exist. They're confronted with issues, and so they're put in a position of needing to, manage this behavior, and it creates a number of issues. There are a couple different realms where we see it come up. In the FMLA and workers' comp arena, if an employee is off of duty, for an alleged injury of some sort, but they then post information on Facebook or Twitter or some sort of photo sharing site that shows them engaging in activity that's explicitly in conflict with what their injury is supposed to be, the employer may be forced with addressing that behavior. In another context, we've seen it arise in some political realms where there's a case out of the Eastern District of Virginia where a sheriff was elected or re-elected, and then after his re-election he fired 6 employees because they had friended on Facebook his competitor in that election. And so that's a case that's currently under appeal right now, so that's a political realm where it came up. Broadly speaking, in terms of the legal issues, one, an employer has to take into account whether or not they're public or private, because certainly for public employers, the First Amendment will be much more in play. But broadly speaking, for their privacy issues, there are protections under the National Labor Relations Act that apply to both public and private employers that have to be taken into account. There are issues around general privacy, whistleblower laws, and general anti-discrimination issues that have to be taken into consideration also. One of the reasons I really enjoy this area is because it is new, it is emerging. I mean, when you think about the Civil Rights Act of 1964, we have case law going back to shortly thereafter that helps to shape how we deal with that law, and even there's still conflicts. Here with social media, the technology is so new, the technology is always changing, that I expect going forward we're going to continue. This is going to be a real prevalent issue going forward, and employers are going to have to be nimble to stay current with the technology and in addressing the employment issues. So in years to come, this will only increase.